think it was your alma mater, Justin.
That's right. Go Bears. Nick
Bears.
was a star competitor at UC Berkeley. He competed for their law school team as well. He competed at the national championship. He was a second chair at Top Gun and a competitor at the Tournament of Champions. He's now a public defender in Northern California, a fantastic trial lawyer, a great guy, and you're in good hands. So I'll turn it over to Judge Cotter. Thanks so much for judging.
Thanks, Justin. All right. Well, it looks like we have everyone here. I just want to confirm, are the witnesses here as well? I see both advocates on screen. All right, I see a defense witness, plaintiff witness. Excellent. Okay, I'm going to confirm with our bailiff. Do we have the go-ahead to get started?
We do.
All right, thanks, Spencer. All right, so we'll call the case of Marks versus Sonny's Rooftop Bar. Let's start with having each party state their appearances, beginning with the plaintiff.
Yes, Your Honor. My name is Ria Lakaraju. I'm joined today by my colleague, Ms. Sarah DeLacy.
Good morning, Your Honor.
Morning.
And together, we're going to be representing the plaintiff, Ms. Ethel Marks.
Thank you very much. Defense?
Good morning, Your Honor. On behalf of the defendant, Sonny's Bar, my name's Bennett Dembski. I'm joined in court by my co-counsel, Ms. Fatima Loan.
Good morning, Your Honor.
Good morning.
And together in court with us today, we have the owner of Sonny's Bar, Mr. Sonny Mehta.
Good morning.
Good morning. All right, thank you very much. Before we press forward to opening statements, any preliminary matters that either party wants to attend? Start with the plaintiff.
Yes, Your Honor. We just have a couple of preliminary matters we'd like to discuss. First, Ms. DeLacy, could we see the pretrial order for this case on screen? And could you zoom in on line items 11 and 13 for us? So, Your Honor, we're going to go ahead and take these one by one. Line item 11 just says that Exhibit 22 is pre-admitted and it may be used at any time for any purpose. We will be using Exhibit 22 today. And Your Honor, line item 13, apologies, Your Honor.
No, that's fine. Go ahead.
Yes, Your Honor. Line item 13 just says that at all times that are relevant, Frankfurt Johnson and Sonny Mehta, those are two employees of the defendant, were acting on behalf of the defendant.
All right, thank you. That's my understanding of both of those orders as well.
Yes, Your Honor. And next, we'd just like to invoke Rule 615 for the constructive sequestration of all witnesses, barring Mr. Mehta, of course.
All right, any objection to that defense?
No, Your Honor. Mr. Mehta will be with us in trial today.
All right, so Mr. Mehta will be present. All other witnesses will be constructively excluded.
Yes, Your Honor. We just have one more matter to discuss. We'd just like to ask about your preferences about screen sharing documents that are not in evidence. It's our understanding that once a document has been admitted into evidence, according to that pretrial Ms. DeLacy just showed us, we don't have to ask permission to screen share it again. But how would you like us to deal with screen sharing those documents for the very first time before they're in evidence?
Sure, yeah, so that I understand that about the pretrial order as well. Once they're admitted, you can do what you like with them. Let's just assume that they're constructively outside the view of the jury and only seen by the witness and the attorneys before they're offered and admitted into evidence.
Yes, Your Honor. And just to clarify that, would you like us to ask permission before we display them from the court or just go ahead and display them on screen?
I know time is tight, so no need to ask permission. Go ahead and just show it, and we'll assume that if it's not in evidence, then the jury can't see it.
Yes, Your Honor. And with that, we're ready to go.
All right, thank you. Plaintiff counsel, defense, anything else?
Just one preliminary matter, Your Honor. We just like to let the court know that throughout today's trial, my second chair and I are going to be reading portions of deposition testimony from an unavailable declarant, Kendall Reutman, throughout the trial. Pursuant to 804B1, this witness's testimony is admissible and it's accepted to the rule against hearsay.
Okay. Ms. Lakaraju, any thoughts on that at this point?
No, Your Honor. That's our understanding as well.
Okay, all right, that's fine. We'll address that as it comes up. And of course, my understanding is that there's no pretrial order stipulation saying that you can't raise evidentiary objections as it's read. If I'm incorrect, please let me know. But we'll address that at that time. But thank you for the heads up.
Yes, Your Honor. With that, defense is ready.
All right, then let's proceed with opening statements. Just as a reminder for our scoring panel and adjudicators, let's make sure now that we're moving into opening statements that we'll switch to gallery view, or sorry, speaker view, and we turn off all of our audio so it doesn't interfere with the advocates. All right, plaintiff, go ahead and proceed whenever you're ready.
Yes, Your Honor. Just a moment. May I proceed?
Yes, you may.
Your Honor, Mr. Dembski, members of the jury. They knew. They saw. They looked the other way. On March 24th, 2019, the Los Angeles Police Department discovered a car in a ravine off a highway. It was upside down. Its windows were shattered. And inside, they found a body. It was the body of a 19-year-old girl, a girl named Jessica Marks. She was found dead on arrival. But to understand what happened to Miss Marks, we have to take a step back. Because you're going to learn today that before she got behind the wheel that day, Miss Marks was at a bar. That bartenders were serving her drink after drink after drink. But she was getting drunk. And the bartenders knew that. And as she took drink after drink, you'll hear that her eyes became bloodshot. Her speech became slurred. Members of the jury, you'll hear that she could barely walk. And that the bartenders saw that. See, they knew she was drunk. They saw she was drunk. But they looked the other way. And that's why we're here today. That's why we're suing the defendant, Sonny's Rooftop Bar, for wrongful death. Because members of the jury, on March 24th of 2019, the employees at that bar had a single responsibility. If someone at their bar was too drunk, they had to be cut off. So all we have to prove today is that the employees served Miss Marks alcohol, even though they knew and saw that she was too drunk, and that their actions caused her death on March 24th. And we have to prove that by preponderance of the evidence. That just means more likely than not. The jury, we're going to meet that burden by proving 3 facts to you today. First, the defendant knew Miss Marks had too much to drink. Second, they saw that she was acting drunk. And third, they looked the other way as they kept on serving her those drinks. Because members of the jury, today you're going to hear about the night of March 24th. You're going to hear that Miss Marks, a minor, entered the bar at 9 p.m. That the moment she arrived, the employees at the bar gave Miss Marks beer, they gave her wine, they gave her hard liquor. And you're going to hear that those same employees saw Miss Marks become more and more drunk. You'll hear that she was slurring her words, stumbling down steps. And members of the jury, what did those employees do? You're going to hear that they looked the other way. That instead of helping Miss Marks, instead of cutting her off, instead of telling her you had too much to drink, they just gave her more and more alcohol. Members of the jury, what happened to Miss Marks on March 24th was a tragedy. That's something we can all agree on. But what makes Miss Marks' death so tragic, it's not just that she was so young. It's that all of this could have been avoided. Because the defendant knew. They saw. But they looked the other way. That's why at the end of today's trial, before you again. And I'm going to ask you to find the defendant liable. Thank you.
Thank you very much, Ms. Lakaraju. Mr. Dembski, opening statement.
Yes, Your Honor. May I proceed?
Yes, whenever you're ready.
May it please the court, Ms. Lakaraju. There was nothing to suspect, so there was nothing to stop. 10 times. That's how many times the owner of Sonny's Bar, Sonny Mehta, walked up to Jessica Marks's table that night. 10 times he went up to clear their plates, to take their orders. 10 times he looked Miss Marks in the eye. 10 times he walked back into that restaurant and he thought to himself, that person is completely fine. There was nothing to suspect. So there was nothing to stop. Members of the jury, no one today is going to try to tell you that Miss Marks's death wasn't a horrible, a senseless tragedy. It was. No one today is going to tell you that Sonny's Bar didn't serve her alcohol. They did. But when the plaintiff comes before you and tells you that my client is responsible for Jessica Marks's death, we're going to show you the very simple reason that isn't true. From what they could see, from what Sonny's Bar could tell, Jessica Marks was absolutely okay. There was nothing to suspect, so there was nothing to stop. And that's a problem for the plaintiff. Because in order to find Sonny's Bar liable under the California Dram Shop Act, the plaintiff needs to show you something called obvious intoxication. In other words, members of the jury, they need to prove by a preponderance of the evidence. That means more likely than not true, that Miss Marks, when she was being served drinks, was so obviously drunk, so clearly impaired, so publicly inebriated, that any reasonable person would have needed to look at her and say, that person is too drunk to keep drinking. And despite what Ms. Lakaraju just told you, at the end of today's trial, if the evidence shows that they didn't know, that they didn't see, members of the jury, you're not allowed to look the other way. You've got to find for the defense. Today, we're going to show you the 3 simple reasons why their story is missing evidence. 3 questions that the defense is not, that the plaintiff is not going to be able to answer. First, what did the bartenders actually see? You're going to meet the owner of Sonny's Bar today, Mr. Mitt. He'll take that stand and he'll walk you through the events of March 24th, how he went up to Ms. Marks's table time and time and time again, clearing plates, taking orders, how he's trained to spot when someone is drunk, but how he saw nothing of the sort, how there was nothing to suspect, so there was nothing to stop. That brings us to number 2. How much did Ms. Marks really have to drink? Because it's true, plaintiff counsel is going to show you a lot of drinks were ordered to that table, but they're not going to be able to prove who drank what, how many drinks were consumed by Ms. Marks, and how many drinks were consumed by her friend, Morgan Levin. In fact, members of the jury, we expect the only evidence they'll show you, the only evidence they have, is the testimony of that friend, their only witness in this case, Morgan Levin. And when you hear that, members of the jury, I expect you'll ask the last question yourselves. Can we trust Morgan Levin? Because the plaintiff's only witness today is also going to be their biggest problem. You're going to learn today that Ms. Levin was drunk that night. You're going to learn today that Ms. Levin is testifying after being threatened with a lawsuit by the plaintiff. You're going to learn that Ms. Levin's story is contradicted by multiple witnesses. So when she takes that stand and testifies today, I want you to ask yourselves, can we trust what she's saying? That's why at the end of today's trial, I'm going to come before you again. I'm going to remind you to ask yourselves those 3 questions. And when you do, you'll see that there was nothing to suspect. So there was nothing to stop. I'll ask you to find for the defense. Thank you.
Thank you very much, Mr. Demski. Plaintiff, would you like to call your first witness?
Yes, Your Honor, the plaintiff calls Miss Morgan Levin.
All right. Ms. Levin is present. You're presumed sworn. Both counsels on screen. Go ahead and start whenever you're ready, Ms. Lafaraju.
Yes, Your Honor. Could you please introduce yourself to the members of the jury?
Hi, I'm Morgan Levin.
Why are you here today, Miss Levin?
I'm here because my best friend Jessica passed away during a car crash 2 years ago.
How do you know Jessica?
Jess was my best friend. We met in middle school. We were basically inseparable until we went to college. That was hard because we were on opposite sides of the country, but you know, we still called like almost every day. I really miss that.
Ma'am, do you remember the exact date that Jessica passed away?
Yeah, it's March 24th, 2019.
I know this might be hard, but I want to talk about that day. Do you remember what you were doing?
Yeah, Jessica was visiting me that day. We met up at our Airbnb and we were planning to go to a bar called Sunny's.
And what time did you get to Jessica's hotel?
Around 8 p.m. or so.
Did you see anything when you got there?
Yeah, I walked inside and I saw Jessica and she had an open bottle of wine.
Would you recognize a photo of that bottle if I showed it to you now?
Sure.
Ms. DeLacy, can we see Exhibit 5 on screen? Ms. Levin, do you recognize this photo?
Yeah, it's a photo from her Instagram of the wine.
Does it look like it's been changed since you last saw it?
No.
Your Honor, plaintiff moves to enter Exhibit 5 into evidence.
Without objection.
All right, it'll be admitted and received.
You told us that you saw this bottle of wine in front of Jessica. Do you know if she drank from it?
Yeah, I think I saw her have 1 or 2 glasses of it.
And do you remember what time you saw her drinking that wine?
Yeah, I was on the phone around 8:18 p.m. I think.
Ms. DeLacy, could we get a timeline on screen, please? And could you put what Ms. Levin just said on the timeline? Ms. Levin, what did you do after you got to Jessica's hotel room?
You know, we hung out for an hour or so, and then we left to go to Sunny's bar.
And around what time did you get to the bar?
9 p.m. I think.
Ms. DeLacy, can we see that on the timeline? And when you got to the bar, what did you do?
You know, we were talking, hanging out, just sort of joking around, and you know, we drank a lot.
Let's talk about exactly what you drank. Do you remember what you ordered?
Yeah, I took some photos when we were out that night. I know there are some of the drinks we had in those photos.
And would you recognize those photos if I showed them to you now?
I would.
Ms. DeLacy, could we see exhibits 11 and 14 on screen? Do you recognize these photos?
I do.
Do either of them look like they've been changed since you last saw them?
No.
Your Honor, plaintiff moves to enter exhibits 11 and 14 into evidence.
Without objection to these 2 photos.
All right, they will both be admitted as well.
Ma'am, can you tell us exactly what drinks are in these photos?
Yeah, so in the one on the left, you can see Jessica and I were drinking some wine. And then in the photo on the right, it was from a little while later, we ordered some more drinks. You can see some beer, more wine, White Claws. Those are like a hard seltzer, and then the thing with the straw is a rum and Coke.
Objection to lack of foundation. May I be heard on those grounds?
Sure, go ahead.
Your Honor, we have a good faith belief that all the drinks on that table, except for the rum and Coke, were ordered by this witness. So of course she'd know what they are. But Your Honor, they've laid absolutely no foundation as to how this witness would know what that rum and Coke is. In fact, Your Honor, we have a good faith belief that drink wasn't ordered by this witness, and that the only way she could say it was a rum and Coke is because she was told that by Jessica Marks, and the foundation would be hearsay.
Okay, so you're just taking issue with the identity of that specific drink, if I'm hearing that correctly, as rooted in hearsay. Is that right?
Yes, Your Honor.
Okay, all right. Plaintiff?
Yes, Your Honor. This witness actually says that she thinks what was on the table that they ordered when they were ordering their drinks was a rum and Coke. Mr. Dembski's objection goes to weight, not admissibility. If he believes that it actually wasn't a rum and Coke and he disagrees with this witness, he can take that up on cross. But this witness's testimony was that based on what she experienced that night, the fact that this drink was on the table in front of her, as we can see in this photo, she believed it was a rum and Coke. If you think
May I respond?
Yeah, go ahead briefly.
Yes, Your Honor. This witness can't experience that drink was a rum and Coke. It's a dark liquid with a lime in it. The only way she could possibly know what was in that drink, what specific type of alcohol was in there with the Coke, is if she was told. We have a good faith basis that the foundation they need to lay to admit this into evidence is based on hearsay. Whichever way opposing counsel cuts it, this testimony is inadmissible.
All right. I understand the point you're making, and I think it's ripe for cross-examination. I'm going to overrule it. She was there that night. She can see it, and she can use what I think is something within her perception to be able to look at these drinks and identify them as she recalls them. Whether or not she drank it is an issue for cross. So I understand the point you're making. It's well taken, but I'm going to invite you to take that up on cross-examination. So overruled.
Yes, Your Honor.
Now, ma'am, can you tell us just one more time the drinks that were in this photo on the right-hand side that we're looking at?
Yeah, there's some beers, more wine, a few White Claws, and rum and Coke.
Mr. Lacey, can we go back to that timeline? Ms. Levin, how long would you say that you and Jessica were drinking at the bar?
From like 9 until after 11 or so.
Mr. Lacey, can we get that on the timeline? How did Jessica seem as you both were drinking?
She was really loud. She was slurring her words. We're making a lot of like silly videos. She just kept getting drunker and drunker. To me, she seemed obviously intoxicated.
Objection to legal conclusion. May I be heard?
Yes.
Obvious intoxication is the exact standard that the plaintiff needs to use in order to prove their case. This witness can, of course, say that she perceived Ms. Marks to be drunk or very intoxicated, but for them to use that phrase in front of the members of the jury, that's a conclusion this witness simply cannot make.
Plaintiff, thoughts on that?
Yes, Your Honor. Your Honor, the phrase obvious intoxication is actually not a legal statute or a legal standard. It's a living and breathing term that is referenced by precedent in civil cases when we're discussing issues like this, like a wrongful death suit where a bar is being sued. That term is based off of perceptions of other witnesses and can be used to explain to a jury how they might be able to understand whether or not someone seemed drunk. It's the same exact thing as the witness saying, she seemed pretty drunk to me. This isn't a legal statute or a term that has any significance in that context.
Can I respond? I apologize.
Hold on. Did you finish, plaintiff counsel? Did you finish up what you were trying, your point?
Yes, Your Honor. I was just saying this isn't actually a legal term that carries weight in an evidentiary sense. It's just something that's used based off of recollections of witnesses and precedent in past cases that can be used for this witness to explain what she saw.
All right. Defense, we were going to respond to that?
Yes, Your Honor. This isn't a living and breathing term from precedent. This is a statutory term that's listed in the California Dram Shop Act, under which this plaintiff has brought suit today. For this witness to say, obviously intoxicated, invades the province of the jury.
Okay, so yeah, I understand the point. I think this is a little bit on the nose, given that it does appear in the jury instructions, and that is one thing that the jury does have to decide. So I'm going to strike that portion of the testimony. Ms. Lakaraja, why don't you re-ask that question and have her just restate her answer in describing her perception. But let's shy away from that term. I do think that since that is the central issue that the jury is tasked with deciding, that could lead to some confusion. So I'm going to sustain it just as to those two words and go ahead and I'm going to allow plaintiff counsel to re-ask that last question.
Yes, Your Honor.
Ms. Levin, can you tell us just one more time how Jessica seemed when you were drinking that night?
Yeah, I mean, she seemed like she was pretty drunk to me.
And you mentioned a couple videos earlier that you were taking that night. Would you recognize one of those videos if I showed them to you now?
Yeah, I would. I took that.
Mr. Lacey, could we see Exhibit 10? Now, ma'am, I know you might not be able to see the whole video right now, but from what you can see, does it look to be the same one that you took?
It does.
Your Honor, at this time, we move to enter Exhibit 10 into evidence.
Any objection?
No, Your Honor, without objection.
All right, it'll be received.
Mr. Lacey, can you please play this video for us?
I are in Hollywood. Hi everyone, Morgan and I are in Hollywood. We're at a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or.
Ma'am, when did you post this video?
It was posted.
Objection to the rule of completeness. May I be heard?
Sure.
We believe there's a bit more in that video. We just asked if they're going to play part of the video for the jury, that they play the whole thing too.
All right, response from the plaintiff?
Yes, Your Honor. In the interest of time, given the nature of this jurisdiction and the rules that we're trying to abide by, we chose not to play the full video, but we're absolutely fine with playing the rest of the video if that's what Mr. Dembski wants to hear.
All right, I understand the local rules that apply in this jurisdiction, so I'm going to overrule it. If you want to play the rest of it, Mr. Dembski, feel free to do that on cross-examination. But let's just assume that the entire video was played for the jury at this time. So well taken. I just don't want to get into issues of gamesmanship that are specific to this, to these local rules. So well taken. Let's constructively play it for the jury, but for purposes of now, you can continue and proceed.
Yes, Your Honor.
Ms. Levin, when did you post that video we just saw?
It was posted at 11 p.m.
And where exactly was that video taken?
Our table at Sunny's, the same one from the photos we showed earlier.
Thank you, Mr. Lacey. You can take that timeline down. After you took that video of Jessica, did she ever seem to sober up to you?
No, she seemed pretty drunk to me from the way she was acting throughout the entire night.
What do you mean?
I mean, after Jessica had a lot to drink, she started acting really drunk. She was going down some steps to the bathroom, and she just like completely tripped and just fell into the owner of the bar.
Did the owner say anything when that happened?
He looked at Jessica, and he turned to the bartender and he yelled, "We might need to cut this one off."
Did the owner say anything else about how Jessica was acting?
Yeah. Later on, he said, "I hope this one's not driving."
And when did he say that?
Right before our last round of drinks.
And what were you drinking when you got that last round?
We took shots.
And who served you those shots?
The owner of the bar, Sunny.
Thank you, Ms. Levin. Your Honor, we have no further questions at this time.
All right, thank you very much. Defense counsel, cross-examination.
Yes, Your Honor.
Go ahead.
Good morning, Ms. Levin. I want to start by saying that I'm very sorry for your loss.
Thank you.
Let's start by talking about how exactly you came to be testifying in this case. Ma'am, you understand that the plaintiff today is Jessica's mother, right?
Yeah, Mrs. Marks.
The mother of your best friend.
Yeah, she was.
Ma'am, when Jessica died, her mom started talking about suing you, right?
Yeah, when she first found out, she she told me that I should have stopped Jessica from getting into the car.
That's a yes to my question. She didn't just say that, she threatened to sue you.
Yeah, at first.
And ma'am, you understand that getting sued in a case like this, it could cost you a lot of money, right?
Yeah.
The money aside, ma'am, you didn't want to get sued by your best friend's mom.
Oh, I didn't want to be sued.
So at some point later on, you started talking to Ms. Marks's attorneys, right?
Yeah, that was a while after. She didn't end up suing me.
And in those conversations with Ms. Marks's attorneys, they didn't talk about suing you. They asked you to testify in this case, right?
Yeah, they asked me about what happened that night.
Ma'am, to be very clear for the members of the jury, you spoke with Ms. Marks's attorneys for 3 hours before you were deposed.
Yeah, that sounds right.
You spoke with Ms. Marks's attorneys, with Ms. Lacaraju, right before you took the stand today, didn't you?
Yeah, for a bit.
Let's be clear about one thing. As we sit here in court today, you're testifying as a witness on behalf of someone who threatened to sue you.
Yeah, she threatened to sue me a while ago.
That's a yes?
Yeah.
So let's talk about whether or not that threat is affecting your testimony here today. Because one thing you've claimed about that night is that you didn't have very much to drink, right?
I had like 3 drinks.
3 drinks, but at no point, ma'am, are you claiming you were drunk, right?
I was definitely buzzed. The alcohol definitely hit me at one point, but I wasn't like drunk.
Ma'am, that is not true, is it?
You know, that's what happened.
Do you remember the name of somebody named Kendall Reutman?
No.
Your Honor, at this time, my co-counsel and I are going to read several excerpts from the deposition of Kendall Reutman into the record. Its authenticity is stipulated to, and Mr. Reutman is an unavailable declarant. My co-counsel is going to be reading the answers to the questions. Page 1, lines 13 to 16. Question. We're here to talk about an incident that occurred on March 24th, 2019. Where were you around 9 p.m. that night?
Sonny's. Watching the end of the Lakers-Kings game.
Page 2, lines 16 to 17. Question. Showing you Exhibit 2, did you see this woman that night?
Yeah, and I saw her on the news the next day. Jessica.
Page 6, lines 6 to 13. Question. Were you concerned about Jessica getting behind the wheel?
She was in better shape than her friend. Her friend could barely.
Action, Your Honor, lack of foundation. May I be heard on that?
Sure.
Your Honor, my objection is specifically to the answer in lines 7 through 8. She was in better shape than her friend. Her friend could barely walk in a straight line. We're missing foundation here about the condition of both of the people that he's describing. He said her friend could barely walk in a straight line to the Uber. We haven't heard anything about how he observed Jessica that night or how she seemed to appear to him at that point. We need to hear that foundation before we hear the testimony that she seemed to be in better shape than her friend. Of course, we understand that this witness can't provide that foundation considering that he's unavailable. So given that, we ask that this testimony be stricken.
May I respond, Your Honor?
Go ahead.
So, Your Honor, we have foundation on the record to suggest that he's able to give this answer. We've heard foundation that he was in the bar that night, and we heard foundation that he recognized Jessica Marks as the person he saw in the bar that night. Again, like we talked about before, Your Honor, in this jurisdiction, we are limited in how much time we have to present our case. Certainly, there is more foundation in this deposition, but we believe what we read onto the record is sufficient for this witness for us to read this witness's answer about how Jessica and the friend were acting that night.
Response to that, Your Honor?
Go ahead.
Your Honor, it's a bar. There could have been plenty of people in that bar. We need to hear foundation that he saw Jessica Marks specifically throughout the night, observed how she was acting. It's not enough foundation to just say that he was in the bar.
May I respond?
Go ahead. Yes.
We have heard foundation that he saw Jessica Marks. The lines I just read were that he recognized a photo of Jessica Marks from the bar that night. And he's about to say in this answer that he saw Jessica Marks and what shape she was in. Certainly that foundation's on the record. If counsel believes that this isn't the right person, she's welcome to cross-examine this witness about it. But Your Honor, we believe foundation's on the record.
Okay, all right. Well, it's well taken. I understand the point, but I think there is evidence sufficient to support a finding that this witness at least was present and did observe these things, so I'm going to overrule it.
Yes, Your Honor.
Yes, Your Honor. Ms. Lowen, were you finished reading that answer?
No. She was in better shape than her friend. Her friend could barely walk in a straight line to the Uber. But I don't think anyone who drank as much as Jessica should get behind the wheel.
How was she walking?
Fine, I guess. I don't really remember. I just remember her friend was wobbling like she'd been in the ring with a boxer.
Thank you, Ms. Lowen. You can take that down. Ma'am, and Ms. Levin, this question's to you. You were the friend who was with Jessica that night, weren't you?
I was with Jessica. Yeah.
When that witness says Jessica was in better shape than you, you're telling us he's wrong?
That's not what I saw. No, I was definitely less drunk than she was.
When that witness says you could barely walk in a straight line, you deny it too?
I could walk. I mean, I had drinks. Don't get me wrong. I definitely could feel them, but I could walk.
That's a yes, ma'am? You're telling us what that witness said is wrong?
The way he described it like that, yeah.
Ma'am, when that witness says you've been wobbling around like you've been in the ring with a boxer for an hour, you deny that as well?
Yeah, like I said, I could feel the alcohol. I wasn't sober, but I wasn't that drunk.
That's a yes?
Sure, yeah.
So we've talked about how much you had to drink. I want to talk now about how much Jessica really had to drink. Because one of the big claims you made on direct examination was that Jessica had quite a lot that night. Isn't that true?
Yeah, we were drinking.
You showed us pictures, right?
Yeah, they put up photos.
Ma'am, I want to be clear. Those photos that they put up, those don't tell us who drank what, do they?
No, they don't.
They just show drinks on a tape.
Right.
Ma'am, the truth is that the fact that your story is that Jessica had so much to drink that night, that hasn't always been what you've claimed, is it?
I'm not quite sure what you mean.
Well, ma'am, you were interviewed by the police the night this crash happened, weren't you?
Yeah, I was in shock after the crash. I actually don't really remember what I said during that.
But ma'am, you do remember that you were interviewed by them?
Yeah.
You spoke with them right after the accident?
Yeah, I was in shock.
You spoke to them long before the plaintiff in this case threatened to sue you?
Yeah.
Can we pull up Exhibit 23? Your Honor, this is a self-authenticating document. It is a police report and pursuant to hearsay exception rule 8038A3. It is a public record. We offer it into evidence at this time with the conclusion that we believe is inadmissible redacted.
All right. Plaintiff counsel, thoughts on admitting it under that exception?
Yes, Your Honor, we don't believe that exception applies here.
All right, and why not?
Your Honor, we don't believe that this is actually a public record. This is a police report. We don't have any foundation that this is in fact a public record. This is just a narrative account of what the police officer observed, and we don't have foundation this was actually publicly available to anyone. So we don't believe that exception applies. Furthermore, Your Honor, there's still significant hearsay within hearsay in this document. So even if the public record exception applied for the police officer's observations, there's a large number of moments in here where he describes things Ms. Levin said or things other witnesses said that would not be covered by the public records exception because they're hearsay within hearsay.
May I respond, Your Honor?
Yes.
So I'll take those one at a time. First, as to the initial layer of hearsay, we do believe the record applies. The record doesn't actually have to be public. It just needs to be a record from a public office. And pursuant to Rule 8038A3, a record like this is admissible if it's being used in the civil case. It says right at the top, automobile accident report, and that's stipulated to, Your Honor. As to the second layer of hearsay, the hearsay within hearsay that Ms. Lakaraju was speaking about, we're actually only interested in a single statement from this document, and we can redact the rest. That's a statement from this witness that we are not using for its truth. We're using it for impeachment purposes.
All right, so that's very different then. So can you point me where on, you can just identify it on the page and maybe we can narrow this issue. Is it page 2, which, oh, thank you, okay. So again, this is all constructively outside the presence of the jury. So only we're seeing this here. So that's the only statement that you wish to admit, Mr. Dembski?
Yes, Your Honor. We believe this document does satisfy the initial layer of hearsay, the public records exception, and we're happy to redact everything else except this one statement, which we are not using for its truth.
All right. Ms. Lakaraju, do you have a problem if that only this statement was admitted for impeachment purposes and the rest of the document was excluded and not shown to the jury or admitted into evidence?
Yes, Your Honor, we do have an issue with that. We don't believe that Mr. Dembski isn't using this document for its truth, or this statement specifically for its truth value. Earlier today, Mr. Dembski said that one of the questions he was here to answer was how much the two people at that bar actually drank. This line clearly displays testimony or observations about how much those two people drank. He must be using this for the truth of the matter asserted, Your Honor.
May I respond to that?
Yes.
So, Your Honor, we're actually going to prove by other evidence, the testimony of Mr. Mehta later, that Jessica Marks didn't have that much to drink and that this witness was drunk. We're not using this for its truth. We're happy with a limiting instruction to say that to the members of the jury. This witness was drunk. We don't trust her recollection at that time. We don't trust her recollection here in court today. We're just using this to show that her two stories are different, and we're using it for impeachment purposes.
All right. Then with that representation, here's what I'm going to do. I'm not going to admit the entire police report. I think there are circumstances where police reports can be admitted in civil cases. I don't think this is one of them, given that this particular police report does, as the plaintiff mentioned, have lots of multiple hearsay issues within it, and certain issues and conclusions that it seems like that the officer came to with the officer not being in court today. So that's my concern about the report in its entirety. This statement made by Ms. Levin, though, is admissible for impeachment only, not for its truth and not as substantive evidence, since it's not made in a sworn capacity. So what I'm going to do is allow this statement to come in to be used only to question and impeach this witness on cross-examination. But it seems like the parties are both amenable to a limiting instruction to limit just this to its use of for impeachment purposes, and it can't be argued for its truth in closing. So
yes, Your Honor.
The order. Go ahead.
Ms. Levin, when you spoke to the police that night, you didn't tell them Jessica was stumbling around drunk, did you?
I guess not. I really don't remember what I said. It was right after the crash. I don't remember any of it.
Ma'am, you didn't tell them she had way too much to drink.
No, I guess not.
Ma'am, you can see on this document, you didn't tell them what you said today in court, did you?
No, I guess not.
You said she had only 3 drinks, right?
Yeah, I said I also had a few, which is what I said today.
Ma'am, I'm going to bring you back to my question. You said she only had 3 drinks, right?
Yeah.
Nothing further.
All right. Any redirect examination by the plaintiff?
Yes, Your Honor. Actually, Ms. DeLacy, could we see that zoom in that Mr. Dembski was just displaying again? Ms. Levin, I'm going to ask you a couple questions about this document. First, did any bartenders or employees at the bar express any concerns to you about how much you drank when you were there?
How much I drank? No.
Did they express concerns about how much Jessica drank?
Yes, they did.
What were those concerns?
They said, I hope this one isn't driving. They said that they should cut her off.
Thank you, ma'am. We have no further questions for this witness, Your Honor.
Oh, all right. Thank you very much. And any recross examination for this witness?
Yes, Your Honor. Ma'am,
Okay, go ahead.
I understand you're saying that's true now. But when you spoke to the police that night, as you can see from that document, you didn't say that.
I said she had a few drinks.
Ma'am, you said she had 3 drinks.
Yeah.
And nothing about the bartender, right?
No, I don't think we talked about the bartenders.
Nothing further.
All right. Thank you. Any further redirect examination for this witness?
No, Your Honor, I don't believe that we have that luxury in this jurisdiction. We're fine with the witness being excused.
All right. Well, thanks for clarifying the local rule. Thank you for your testimony, Ms. Levin. You may be excused. And anything further from the plaintiff at this time?
Nothing further from the plaintiff, Your Honor.
Okay. We'll assume the plaintiff rests. Defense. Any
Defense.
evidence or witnesses you'd like to present?
Yes, Your Honor. Defense calls the bar owner, Sonny Mehta, to the stand.
All right. There we go. Sonny Mehta is present. Both parties are present. Mr. Mehta, you're presumed sworn. And Mr. Dembski, you can proceed whenever you're ready.
Yes, Your Honor. Good afternoon. Can you please introduce yourself to the members of the jury?
Good afternoon or morning here in LA. My name is Sonny Mehta.
Can you tell us what you do for a living?
Sure, I'm an entrepreneur. Currently working on opening up a new restaurant in LA post-pandemic. But most recently, I was the owner and operator of Sonny's Rooftop Bar.
Do you know why you're here in court today?
Yes, sir. In March of 2019, a young woman named Jessica Marks came to our bar. They're saying we overserved her, and that led to her death.
I want to get this right out of the way, Mr. Mehta. At any point that night when you served Jessica Marks alcohol, did she seem drunk to you?
No, sir. My job is all about trust. We're a local neighborhood bar, and most of the people that come to our bar were regulars, people I knew by name. It was always important to me that the people who came to my bar got home safe. That was true of Jessica too.
Have you been in court all day, sir?
Yes, I have.
So we heard Ms. Levin testify that Jessica almost ran into you falling down the stairs. Did that happen?
No, I don't remember anything like that happening.
We heard a claim that you said you needed to cut Jessica off. Did that happen?
No, I wouldn't say that. If I thought someone needed to be cut off, I would do it, not just say it.
Did you ever say you hoped Jessica wasn't going to be driving like Ms. Levin said?
No, again, I wouldn't just say I hope someone doesn't drive. I would make sure that I take their keys and call them a cab. It's my job.
So let's go back to the beginning, Mr. Mehta, and walk through the events of March 24th, 2019. What time did Jessica Marks come into your bar?
Well, it was a slow night. I remember her coming in a bit after dinner service had ended, so about 9 p.m.
Was Ms. Marks alone when she walked in?
No, her friend Morgan Levin, who we heard from earlier today, she was with her.
Sir, I'm showing you exhibits 8 and 9. What are these photos of?
These are photos of our bar. The first one, exhibit 8, is the rooftop during the day, of course. And 9 is what our bar looks like, the floor down, the bar area where we make drinks.
Are these fair and accurate photos from the day of March 24th, 2019?
Yes, earlier that day.
Your Honor, we offer these photos into evidence.
Any objection?
No, Your Honor.
All right, they'll be admitted and received.
So, sir, could you tell us where in these pictures Jessica and her friend were sitting?
Sure. So they were on the rooftop. So the first photo, and they were sitting at the chairs and tables on the bottom right there.
Let the record reflect on marking the space where the witness just indicated with a red circle. Just for context, sir, that night, how many other people were sitting on this rooftop with the two of them?
Well, I would say at any one time that night, about 14 people total.
You said there are 14 people there. At any given point during the night, were you giving Jessica and Morgan your full attention?
Well, of course, whenever I was taking their order or serving them drinks, I would be looking at them then.
Were you on the rooftop for most of the night?
No, I only go up to the rooftop to deliver those drinks, maybe have a chat while I'm up there, but most of the time I'm downstairs making sure everything's in order and making sure the drinks are getting out well.
So, sir, I want to talk now about your interactions with Jessica and Morgan. Tell us, sir, can you know when someone's drunk?
Well, sure. Again, that's part of my job. We're trained. Well, in order to get your liquor license in California, you have to go through training that tells you exactly what to look for. And also a lot of it's just common sense. You know, when you look at someone, you can kind of tell if someone's been drinking.
How do you judge if they've been drinking?
Well, again, from the training and just common sense, I look for how their eyes are looking. Are they red or watery? How are they speaking? Slurred speech? Are they loud and boisterous? And then obviously, if they're moving around or are they stumbling, are they able to keep their balance?
Sir, when you first saw Miss Marks at 9 p.m. when she came into your bar, did she have any of those symptoms of intoxication?
Oh, no, we wouldn't have given her any drinks if she was showing those signs at the bar.
How many times over the course of the night would you say you interacted with Jessica Marks?
It's a rough estimate, obviously, but I would say 10 at the most.
10 times, sir. In the 10 times you saw Miss Marks, were her eyes red or watery?
Not from what I can remember, no.
Was she slurring her words?
Not when I was speaking to her, no.
Despite what Ms. Levin said, in the 10 times you saw her, was she stumbling?
I didn't see her stumble, no.
Let the record reflect we've placed a red X next to each one of those characteristics of intoxication to indicate that this witness didn't see. Sir, with that considered, did you have any reason to believe Ms. Marks was intoxicated in the 10 times you saw her?
No.
So we've talked about what you saw from Jessica Marks. I want to move now and talk about the friend, Morgan Levin. Did Morgan Levin ever have red or watery eyes?
Well, yes, Morgan was a different story. I noticed, especially later in the night, Morgan's eyes were red.
Was Morgan slurring her words?
Yes.
Did Morgan stumble?
Yes, especially as she was leaving the bar.
Let the record reflect we've placed a green check next to each one of those characteristics to indicate that this witness saw the friend acting intoxicated. Sir, I want to talk now about what happened when Ms. Marks and Ms. Levin left your bar. Did you speak to him?
I did. I talked to them as they were leaving just to make sure who was driving.
Ms. Levin, could we put that on the timeline, please? Whoa, sorry, sir. What time did they leave?
About 11:45.
Let's put that on the timeline. Sir, does this timeline accurately reflect your testimony in court today?
Yes, it does.
Thank you, Ms. Levin. You can take it down. Sir, when they were leaving at 11:45, what did you say to him?
Well, I spoke to them and I made sure that Morgan wasn't going to be driving.
Why?
Like I mentioned, Morgan was showing those signs of being at least buzzed. And when someone shows those signs, I have to make sure that they're not going to be trying to drive home.
Did that friend Morgan tell you if she was going to be driving?
She told me that her friend was going to drive, Jessica.
Sir, when Jessica Marks walked out of your bar, were you worried about her driving?
No. Listen, I've worked in bars for years. I've seen a lot of drunk people. And if I could go back, I'd do anything to stop that young woman from getting behind the wheel. But at the time, I thought she was sober. There was nothing to suspect.
So did you stop her?
No.
Thank you, Mr. Mayta. Nothing further.
All right, thank you very much. Plaintiff counsel, cross-examination?
Yes, Your Honor, just one moment.
Yeah, of course, go ahead. Take your time.
May I proceed, Your Honor?
Yes, go ahead.
Mr. Mehta, I'm going to be asking you some questions today. If at any point you can't hear me, just go ahead and let me know, all right?
I will.
Now, let's start by talking about what you knew on March 24th of 2019, okay?
Okay.
You'd agree that you served Jessica Marks alcohol that evening.
We did.
You know that on night, Miss Marks and her friend, they ordered quite a bit of alcohol.
Well, they ordered about 7 or 8 drinks across 3 hours.
Well, you'd recognize a receipt of all the drinks they ordered from that evening if I showed one to you now, right?
I would.
Ms. DeLacy, could we see Exhibit 17, please? Sir, you recognize this receipt, right?
Yeah, that's the receipt I gave Morgan that night at the end of the night.
It doesn't look like it's been changed since you last saw it.
Nope, it looks exactly how it looked that night.
And you'd agree that this receipt, it was made on March 24th of 2019, right?
It was.
You'd agree that making receipts like this one, it's a regular practice of your business.
Yeah, of course. We're trying to make some money as well, so we make receipts with every order that comes in.
Yes, Your Honor. Your Honor, this time the plaintiff moves to enter Exhibit 17 into evidence.
Objection, Your Honor, to hearsay. May I be heard on those grounds?
Go ahead.
Your Honor, we understand that the plaintiff is attempting to qualify this document as a record of regularly conducted business activity. There's just one more piece of foundation they need to lay, that this witness was the custodian of those receipts. We just ask that they ask one more question about it, and then we're fine with it being entered once that foundation's been laid.
Ms. Lakaraju, the response to that point?
Yes, Your Honor. It's actually not necessary that we lay that foundation. Under that requirement that Mr. Dembski is referencing, we can show that the witness was a custodian of the document, or we can show that the witness was an owner of the document or had knowledge that this document was in fact something that would have been made as a record of a regularly conducted business activity. Your Honor, this witness already said that he's the owner of the bar. He actually created this receipt and handed it to Ms. Marks and her friend. He certainly has knowledge that it is a record of a regularly conducted business activity, so it satisfies all the prongs of 8036.
May I respond?
Sure.
Your Honor, while they do need to show that this witness had knowledge it was a regularly kept record of business, they do still need to show through the testimony of a custodian that to meet the fifth prong of 8036. And absent that testimony about this witness being a custodian, the document is inadmissible. We just like them to ask that one more question before this document is shown to the jury.
Your Honor, just briefly.
Go ahead.
Your Honor, I actually have the rules in front of me right now. I can go ahead and read aloud that prong that Mr. Dembski is mentioning. He's talking about 8036D. That says all these conditions, referencing the conditions that this was in fact kept in regularly conducted business course of this organization. It says all these conditions are shown by the testimony of the custodian or another qualified witness, or by a certification that complies with Rule 902.11. Your Honor, we've met the second requirement of those three, that it's being established as a record of a regularly conducted business activity by a qualified witness. We know this witness is qualified. He's the owner of the bar, and he made the receipt.
All right. Yeah, I tend to agree. I mean, I understand this witness isn't the custodian of this particular document necessarily, but they are another qualified witness within the meaning of that of prong D of the rule. So well taken, but I will overrule the objection and the exhibit will be received.
Yes, Your Honor.
Now, Mr. Mehta, according to this receipt, Ms. Marks and her friend, they ordered 3 White Claws.
That's right. It's a hard seltzer.
They ordered 2 beers.
Yes,
And 2 green tea shots.
that's right.
And sir, a green tea shot, just to be clear, that's not actually green tea. That's hard liquor.
That's right. We just call it a green tea shot. It's there's a little bit of whiskey, a little bit of peach schnapps, and some Sprite.
And sir, all of that was ordered in the span of about 2 hours.
Closer to 3, but yes.
So between 2 and 3 hours.
Yes.
So let's talk about what you saw after they ordered all of those drinks. Now, you said a few moments ago that Miss Marks did not seem intoxicated that night, right?
Not to me, ma'am. No,
Sir, you were in court when Morgan Levin testified, right?
I was.
You heard her say that Miss Marks was stumbling.
I did hear Morgan say that. Yes.
You heard her say that Miss Marks's eyes, they were bloodshot.
I heard her say that.
You heard her say that Miss Marks seemed drunk.
Yes, and I just didn't see that.
That's right. So you're telling us you don't agree with what Miss Levin saw, right?
I mean, insofar as I saw those signs she was talking about, I only saw Morgan herself showing them.
Well, sir, let's talk about something we can both see right now. Mr. Lacey, could we see Exhibit 10, please, Your Honor? This is already in evidence. And Mr. Lacey, could you just play this one more time for the members of the jury?
Hi everyone, Morgan and I are in Hollywood. We're at a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. You know, I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
Mr. Mehta, you'd agree that video we just saw, that was taken while Miss Marks was at your bar.
That's right. That video from the background, I can tell it's the rooftop.
It was taken at some point before she arrived and before she left.
Yes.
Sir, she was slurring her words in that video.
Yeah, a bit at the beginning.
There were 4 drinks in front of her.
I don't remember exactly, but I believe you. Sure.
Sir, you'd have to agree that in that video, Miss Marks appears intoxicated.
Again, ma'am, I haven't seen her walk. I couldn't see her eyes there. I wouldn't say she was drunk necessarily. She looks tipsy for sure, maybe 1 or 2 drinks in.
Hang on, sir. You wouldn't say that she was drunk in that video?
Again, I'd say she's tipsy, a couple drinks in maybe, but I wouldn't cut her off at that point, just from what I saw there.
All right, sir, let's walk through everything you just said. You said a couple drinks maybe, right?
Yes.
You saw 4 drinks in front of
Yeah, on the table, her and Morgan.
her. You know that she was slurring her words in that video.
Yes, at the beginning, sure.
You saw that she had a little bit of trouble picking up a can in front of her.
No, I didn't see that. I saw her reach for something.
Sir, you saw her say, go big or go home at the end of that video and chug a can of alcohol.
Yes, the White Claw, I saw that.
You saw that she couldn't really put her glasses straight on her face.
Sure, the sunglasses. Yeah.
Or she just seemed a little bit tipsy to you, right?
If I were looking at her, I would say she's tipsy. Like I said, I wouldn't cut her off from what I saw in that video.
Well, sir, on the night that video was taken, you were in charge of the bar, weren't you?
Yes, I was downstairs most of the night, but I was upstairs as well.
Well, I want to ask you very plainly. Is there anything you would have done differently that evening?
Well, of course, knowing what I know now, knowing now that she was drunk, knowing now that she's 19, I wouldn't even let her in the bar.
Sir, knowing now that she was drunk, you would have done things differently?
Yes, ma'am, if I had known then what I know now, but ma'am, at the time, there's nothing to suspect, and I can't go back.
Sir, you're telling us there was nothing to suspect?
Nothing from what I saw, no.
Well, sir, let's talk about all the times that you saw Jessica Marks, because you saw her when she walked into your bar, right?
Yes, ma'am, at 9 p.m.
Like you said, you served her 10 times that night.
No, I was upstairs near her table 10 times, probably only served her maybe 3 or 4 times.
All right, sir, so you were in front of her table 10 times.
That's right.
Naturally, you saw her when you were standing in front of her table.
Yes.
Sir, I'm going to show you Miss Marks's autopsy from that same night. Mr. Lacey, could we see Exhibit 22? Your Honor, this is already in evidence. Sir, you'd agree that you certainly saw Miss Marks as she was leaving your bar, right?
Yes, as she was walking down the stairs.
You'd agree that Miss Marks left your bar with a BAC of 0.16.
That's what this report says.
You know that's twice the legal limit.
Sure, for driving, yes.
Now, sir, I know you said Miss Marks, she didn't seem that drunk to you, but you know that after she left your bar, she got into a car accident.
I know that now.
And you know that she passed away in that accident.
I do.
Nothing further, Your Honor.
All right, thank you very much. Any redirect examination for this witness?
Yes, Your Honor.
All right, go ahead.
Mr. Mehta, you were asked a lot of questions by Ms. Lakkaraju about what we know now. I want to focus on what you knew then. Did you know her BAC was 0.16 when she was in your bar?
No, of course not. I would have never let her leave in that car if I did.
That video they showed you on cross-examination, did you see her acting like that when you were near her table?
No, sir. I didn't even see her looking tipsy like that.
I want to talk now about the receipt Ms. Lakkaraju asked you some questions about. Could we get that exhibit up, the receipt? Sir, do you know who drank which drinks from this receipt?
No, sir. I just brought them to the table where she and Morgan were both sitting.
All right, sir, and I want to talk about just one more thing. Ms. Lakaraju asked you about Ms. Levin's testimony, how it's true that Ms. Levin says that Jessica was drunk, right?
That's right.
You've said that it was Ms. Levin who was drunk, right?
Yes, sir.
So, Mr. Mehta, what I want to ask you is, were you here in court when we read the testimony of Kendall Reutman?
Yes, Mr. Reutman was one of the other customers there that night.
Let me ask you, does Mr. Reutman work for you?
Oh, no,
Do you know him at all?
not personally, no.
Do you remember what he said?
I remember he said that he looked at the two of them and thought Morgan was the one that was more drunk.
Thank you, sir. Nothing further.
All right. Any recross examination?
No recross.
All right. Thank you very much. May this witness be excused, Mr. Dembski?
Yes, Your Honor, we're fine with this witness stepping down, and with that, we close our case.
All right. Thank you very much, Mr. Mehta. Okay, great. Then with that, we'll proceed to closing arguments. Maybe give us just a sec so we can make sure. I know they're off screen. I can't see them, but let's maybe give it 30 seconds just so we can make sure all our panelists can make sure they get their notes straight and stuff before we go into closing argument.
Yes, Your Honor.
All right. All right. If everyone's good, we can, I think it looks like most people in what I'm sensing are ready. Just want to make sure our advocates are good and just want to make sure I gave our scorers an opportunity to pause.
Defense is back and ready, Your Honor.
All right, great. Okay, then we'll proceed to closing arguments. Ms. Lakaraju, whenever you're ready, you may proceed.
Yes, Your Honor. Just one moment. Your Honor, Mr. Dembski, members of the jury. Today you heard two different versions of what happened at Sonny's rooftop bar. But we can all agree on one thing. What happened after Miss Marks left that parking lot? What happened after she drove down the highway? That was a tragedy. A 19-year-old's life was cut short far too soon. So that's why today I got up here and I asked Mr. Mehta, would you have done anything differently on March 24th? And he looked at us and he said, knowing what I know now, yes. Members of the jury, do you know why he said that? Because on March 24th of 2019, Mr. Mehta and his employees, that's when they knew that Jessica Marks was far too drunk. That's when they saw that she was far too drunk. And members of the jury, they looked the other way. And that's why we are here today. That's why we're suing the defendant for wrongful death. That means we had to prove that it was more likely than not that the employees at Sunny's rooftop bar gave alcohol to a minor who was obviously intoxicated, which led to Miss Marks' tragic death. In other words, we had to show it was more likely than not that the defendant knew Miss Marks had a lot to drink. The defendant saw that she was too drunk, and they looked the other way. So first, what they knew. Because we heard today that before Miss Marks even got to the bar on March 24th, she was already drinking. Because we know that at 8:18 p.m., Miss Marks drank wine. And members of the jury, when she got to the bar at 9 p.m., we heard that employees started bringing Miss Marks drink after drink. Members of the jury, we heard about wine, we heard about beer, we even heard about shots of hard liquor. But that wasn't the only problem. Because of course, it's illegal to give alcohol to a minor, but that's not the only reason we're here today. We're also here because of what the defendant saw. We are here today because after Miss Marks had drink after drink, she became drunk. Members of the jury, of course she did. So what did the employees at the bar do? Did they take her keys away? Did they call her a ride? At the very least, did they just stop giving her drinks? No. Members of the jury, what did we hear today? We heard that the defendant looked the other way. That right after Miss Marks stumbled down the steps, after she fell on top of the owner of the bar, Mr. Mehta, after Mr. Mehta said himself, "We might need to cut this one off. I hope she's not driving tonight." Members of the jury, after he said those words, what did he do? He gave Miss Marks another shot of hard liquor. Because members of the jury, it's clear that they knew she was drunk. They saw she was drunk. But instead of helping her, they just looked the other way. But today, the defense, they want you to believe another story. They want you to think that after drinking wine, beer, liquor, Miss Marks looked absolutely fine. Well, members of the jury, why don't we see for ourselves? Ms. DeLacy, could we see Exhibit 10?
Hi everyone, Morgan and I are in Hollywood. We're at a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model.
Members of the jury, the defense, they want you to believe that person was sober? Mr. Dembski, during his opening statement, told you 10 times over and over again, 10 times, Mr. Mehta saw Miss Marks that night. We know that video was taken in the middle of that 10 times. He really wants you to believe Mr. Mehta never saw her acting anything like this? That the person who was slurring her words, who could barely get through a sentence, who couldn't put her glasses on her face straight, that person wasn't obviously drunk? Members of the jury, maybe the bar employees couldn't see that, but we can see it for ourselves. But if you're still not convinced, then I want you to remember not a moment, not a quote, but a number. 0.16. The blood alcohol concentration of Miss Marks when she passed away on March 24th. The blood alcohol concentration of a 19-year-old woman moments after she drove away from Sunny's rooftop bar. The blood alcohol concentration of a 19-year-old who would still be with us today if those bar employees had just done their job. But they didn't. Because they knew Miss Marks was too drunk. They saw that she was too drunk. And instead of helping a young woman in need, they just looked the other way. That's why we're asking you to hold them accountable. Find them liable. Thank you.
Thank you very much. Defense, closing argument?
Yes, Your Honor, may I proceed?
Yes, go ahead.
Ms. Lakaraju, and may it please the court. There was nothing to suspect, so there was nothing to stop. When tragedy strikes, as human beings, we have a tendency, an impulse to want somebody held accountable. And when a young girl with a bright future ends up dead at the bottom of a ravine in a car wreck, it's difficult to grapple with a simple truth that sometimes accidents happen, and they happen for no good reason at all. It's easy to jump to conclusions. It's easy to find a story, to file a lawsuit, to choose the most convenient villain. And in this case, that's exactly what the plaintiff has done. Sunny Mehta's bar is not responsible for Jessica Marks's death. They didn't suspect that Ms. Marks needed to stop drinking, so they didn't cut her off. And that's a problem for the plaintiff. Because in order for you to find Sunny's bar liable under the California Dram Shop Act, the plaintiff didn't just have to prove that Jessica Marks purchased alcohol from the bar. They didn't just have to prove that the bar served her too much alcohol. No, they had to prove that the bar knew that she was obviously intoxicated and that they served her alcohol anyway, and where we disagree with the plaintiff. What they have failed to prove to you today by the weight of the evidence is that Sunny's bar saw signs of obvious intoxication. So to talk about how the plaintiff has failed to meet their burden, I want to return to the 3 questions I asked you at the start of today's trial. What did the bartenders actually see? How much did Ms. Marks really have to drink? Can we trust Morgan Levin? So let's start with the first. What did the bartenders actually see? You know, members of the jury, Ms. Lakaraju spoke a lot on closing about what we know now, the BAC, that video, but there's a crucial distinction to be made here. This case doesn't hinge on what we know now. It hinges on what they knew then. That's what's so ironic about that phrase Ms. Lakaraju's been saying all trial. She literally acknowledges that's what's important. They knew. 10 times, Sunny Mehta walked over to Ms. Marks's table. That's what their witness told. Sunny Mehta spoke to her and didn't see anything. No bloodshot eyes, no slurred speech, no falling over. Mr. Mehta looked her in the eye and saw a girl who had been drinking, but not a girl who was drunk. Today, Mr. Mehta looked you in the eye. He told you that's exactly what happened, but we're not going to ask you to take Mr. Mehta's word for it, because that testimony is corroborated by somebody else at the bar that night. Kendall Roitman. He told you that's exactly what he saw too. Jessica Marks wasn't the one who was drunk, it was Morgan Levin. That brings us to the second question. How much did Ms. Marks really had to drink? And this one, members of the jury, is quite interesting because the plaintiff has asked you to come up here and take those receipts for granted. Let's look at those receipts. Like, the mere fact that there are drinks listed here means that Ms. Marks must have consumed them. But we know from the testimony of multiple witnesses that just isn't true. Morgan Levin consumed a whole bunch of these drinks. That's what Mr. Mehta told you he saw. And that testimony is corroborated once again by Kendall Roitman. And this, members of the jury, is what's so crucial about Mr. Roitman's testimony. He doesn't work for the plaintiff. He doesn't work for the defense. He was a guy at the bar. He has no dog in this fight. And he told you with no bias, no interest, no motive in this case that Ms. Levin, their only witness in this case, was in way worse shape than Jessica Marks. That brings us to question number 3. Can we trust what Morgan Levin has to say? Members of the jury, we can't. And it's not just because Morgan Levin feels responsible for Jessica Marks' death. It's not just because Morgan Levin has motive not to tell the truth. It's not just because Morgan Levin was going to get sued by this plaintiff who's asking you to take her word today. It's not just the fact that she talked to their lawyers before she was deposed. It's not just the fact that she spoke with their lawyers before she testified today. It's not just that she couldn't keep her story straight between the night of the accident and her testimony in court today. It's the fact that she was drunk that night. We heard that from Mr. Mehta, and we heard that from Kendall Reutman. So when the plaintiff comes before you, when Ms. Lakkaraju returns to your screen in just a minute and asks you to take Ms. Levin at her word, when they stake the entire fate of their lawsuit on the testimony of a single witness, I want you to remember that we can't believe a single word out of her mouth. We can't trust Morgan Levin. But I know. A 19-year-old girl is dead. The plaintiff's family has been torn apart by this case, and they want someone to blame for that. Ms. Lakkaraju wants someone to blame for that. You want someone to blame for that. I want someone to blame for that. Here's the problem. Sometimes we get so caught up in blame, in who wins and who loses, that we lose sight of why we're here. Because it isn't to blame. And it isn't to win, and it isn't to guess. It's to help you find the truth. And the truth is that sometimes there are cases like these, cases where nobody wins, cases where no one's to blame. Make no mistake, members of the jury, if you find the wrong person liable for Jessica Marks's death, everyone loses. There was nothing to suspect. So there was nothing to stop. Find Sonny's bar not liable. Thank you.
All right, thank you very much. Rebuttal from the plaintiff?
Yes, Your Honor, just one moment.
Sure.
May I proceed?
Yes, go ahead.
Members of the jury, I want you to just focus on two words that Mr. Dembski mentioned. Obviously drunk. Because see, he's right. That's what this case is about. Because today, members of the jury, Mr. Mehta can tell you, I didn't see anything. She didn't seem drunk. All he was. But it doesn't change that today we saw for our own eyes what was happening right in front of Mr. Mehta's face. Those 10 times that he was standing right in front of Ms. Marks. Members of the jury, we saw a video of Ms. Marks appearing obviously drunk. A video taken at the same time Mr. Mehta was serving her drink after drink after drink, watching her, visiting her table over and over and over again. And the defense says there was nothing to suspect, so there was nothing to stop. Members of the jury, that is absurd. And Mr. Mehta knows it. That's why he told you himself today. If I could go back, I'd do anything to stop her from getting behind the wheel of that car. Members of the jury, he knew she was drunk. He saw she was drunk. But he looked the other way. Find the bar live. Thank you.
All right, thank you very much. The matter is submitted. I'm going to hand it back over to our bailiff, and I think he is going to confirm with us when all the ballots have been received. So if you give